Now we're going to talk about Chapter 17, third parties. So a third-party beneficiary is someone who isn't a party to the original contract but stands to benefit. Now we have intended beneficiaries, which is someone who may enforce the contract made between two other parties. And then we have the promisor is the person who makes the promise, and the promisee is the other party in the contract. A third-party beneficiary must show two things in order to enforce a contract that two other people created. So they must show that the two contracting parties are aware of the situation and knew that that person would receive something of value. They must also show that the promisee wanted to benefit them for one of two valid reasons, either to satisfy some duty owed or to make a gift. Please review the case in the book on page 411. Now, we also have incidental beneficiaries, which is someone who might have benefited from a contract between two parties, but has no right to enforce that agreement. Assignment is when we transfer contract rights, and delegation is when we transfer contract duties. Now, the obligor is the party who's obligated to do something. So what can be assigned? Well, any contractual right can be assigned unless that assignment would be a substantial change of the rights and duties under the contract, is forbidden by public policy or law, or there's an explicit contract prohibition in the contract itself against assignment. So how are these rights assigned? Well, first of all, the writing requirement. An assignment can govern either a written or oral agreement, so there's no particular formalities, but if the statute of frauds applies, then it must be done in writing. Consideration. So you can have an assignment with or without consideration, but if you don't have consideration, it's irrevocable. Sorry, if you have consideration, it's irrevocable. If you do not have consideration, then it's revocable if it's oral and irrevocable if it's written. Now, these are general statements. In the law, it all depends on the circumstances, but that's the general case. As far as notice goes to the obligor, that assignment is valid even if no one notifies the obligor. But notice is a good idea. Next, we move into delegation of duties as opposed to assignment. So with delegation, most duties are delegable, but delegation does not relieve the delegator of liability to perform under the contract. So what duties can be delegated? Pretty much anything unless it violates public policy, the contract prohibits delegation, or the obligee has a substantial interest in personal performance by the obligor. An example being an artist or a craftsperson, a performing arts person like an actor or actress, okay? Then the last topic is novation. So a novation is a three-way agreement where you've got the third party and the delegator and the obligor